Everyone hear us, hopefully. Hi, everyone. Thank you for joining us today for a 2 p.m. webinar, not 2:30, even though it says it on there. My name is Beth Cohen-King, and I'm the Marketing Director at Margolis & Bloom. So we work with our clients to find the best estate planning or elder law solution for each client's unique situation and goals. And we bring to this effort 30 years of experience and a commitment to providing the highest level of personalized service. So today we are presenting MassHealth Planning and Real Estate, and this will be presented by Harry Margolis. If you have questions during the presentation, please type them into the question box in the control panel on the right side of your computer, and we will also have time for questions at the end. So I do want to turn it over to our presenter, Harry Margolis, but not without saying, very recently he was named Super Lawyer again, and he's had this recognition since 2005, and in different years recognized as one of the top 100 attorneys in New England and Massachusetts. So we're excited to have that news, and with that, I will let you take it away, Harry. Thank you.
Okay, thank you, Beth. So, okay. Trying to change slide here. Next one.
Now try.
Here we go. Oh, that's us. And just to give you an idea of what we're going to do today, first I'm going to give an overview, then it's going kind of just clockwise around here, around this those arrows, and then talk about the MassHealth rules, then options for planning for your real estate, and then finally we'll entertain as many questions that you type in as we can. So before I get into that, I just want to say a few words about why we're talking about this. And the reason is, of course, that for most people, their house is their most important asset, both financially and in terms of their feelings about it. It's often where they've raised their family. Sometimes they may have inherited the house from their parents or grandparents. And so preserving it is of prime importance to most, if not all of our clients. So that's important, and it's also a unique asset, which we'll get into as far as MassHealth rules are concerned. So it gets its own planning, and it's different from other assets for a lot of people because it's not liquid. I mean, you can borrow money against it either through a home equity line or reverse mortgage, but it's not as easily liquid as a bank account or a stock account or something like that, which also affects how people think about it. And if they expect to need long-term care, they may feel comfortable, or at least not too uncomfortable, about spending down their savings to pay for their care, since to some extent that's why they saved. They saved during their lives so that they can take care of themselves when they're older and can no longer work. But they feel less comfortable about digging into the equity into their home. And so they may choose not to protect their savings and investments and have those available for what they need, but then choose to protect the home, which is why we're going to talk about this. So starting with the main rules of MassHealth. So the main rule is that if you need MassHealth coverage for long-term care, and we're going to be talking mostly here about MassHealth coverage of nursing home care, but MassHealth, fortunately, has been expanding what it covers in recent years. So it also covers assisted living care in some situations and home care in some situations, but the rules are different sometimes for the different non-nursing home MassHealth coverage, and one big thing that's different is they can also be different if you're not in a nursing home. If you're under 65, there's one set of rules, and if you're over 65, there's another set of rules. But to keep things simple, we're going to talk primarily about nursing home care. And for nursing home care, and I guess I'm just going to break the rule I just said, and for community care, if you're over age 65, community coverage, you're limited to $2,000 in countable assets. If you're married, your spouse is limited to $123,600, so together about $125,000. But that doesn't include the house. So the house is non-countable If its equity is less than $858,000, and so equity is its fair market value less any loans on it. So if you have a house that has a fair market value of $900,000, but you have a $100,000 home equity line, then that's still a non-countable asset. Or if your spouse is living there, it's still a non-countable asset. So it could be $1 million house, it's over this equity limit, but your spouse is living there, and there's certain other categories of basically a child who's disabled, if they're living there, that's also non-countable. So so most houses are not countable and don't have to be spent down to the $2,000 to or $125,000 limit. So so the next thing I want to tell you about is transfer rules. So I may be getting a little out of order here in a way because I'm talking about the transfer rules before we're talking about why you might want to transfer. So we'll get to that later. But so MassHealth, if you have countable assets, doesn't want you to transfer them and say at $200,000 in a bank account, and you give it to your son, and then the next day move to a nursing home and say MassHealth pay for me. They don't want to do that because they don't want you to create your eligibility that way by giving assets away. So they have a two-part penalty for giving away assets. And so one part is you're ineligible for 1 month for every $10,767.50 you give away. So if you give away $107,600, how does that work? $107,067, $675, then you're going to be ineligible for 10 months. But the ineligibility period does not begin until you move to the nursing home and you spent down the rest of your assets. So let's give an example here. So if on June 1st I gave away $55,000 to my son, and then got some of the dates wrong here. So February 1st, 2019, so this coming February 1st, we moved to a nursing home, or the senior moved to a nursing home, or if I'm the senior, I moved to a nursing home. And then it took me until August 1st of next year to spend down to $2,000, then that's when the 10-month period begins. Or in this case, it's less than 10 months, but the penalty period begins for $55,000, and I'm not eligible, or the senior is not eligible for MassHealth coverage until February 1st. So you got to transfer the assets, enter the nursing home, and spend down to $2,000 for the penalty period to begin. And so it's complicated. And the bottom line, however, is if you're planning ahead, don't even get into any of that. Because you only have to report transfers when you apply, going back 5 years. So the bottom line is just think of it as a 5-year penalty in most cases for anything you transfer. So if you're transferring an asset and you're doing it for advanced planning for MassHealth eligibility, then assume that you're not going to get benefits for 5 years. And if it's possible to shorten that period because worse comes to worse, we could work that out. But and especially if we're talking about a large asset like a house, which is probably going to be very valuable, then once you do the formula, 1 month for every $10,000, you're probably going to end up with 5 years anyway. So so figure 5 years. There are exceptions to this, and these are important. There's no transfer penalty for a transfer to a spouse, to your own child who's blind or disabled, to a trust for the benefit of your child who's blind or disabled, to a trust for the sole benefit of any disabled individual under age 65. They don't have to be your child. And actually, I'm not sure what the last one is there. Trust for the benefit of the applicant under certain circumstances. I think there's some rules on the books for that, but we don't do it in Massachusetts. So we'll take that off the slide next time. I should have caught that. So those are transfers of anything. And then there are additional exceptions that are just applied to transfers of the house. So, if you happen to have a child, again, your child who's under age 21, there's no penalty for transferring the house to them, except that you might not want to transfer a house to someone who's under age 21. There's a sibling exception. So if you and your brother and sister are living in this house together, and you both have an ownership interest already, so for instance, if you inherited it from your parents, and you've been living there for at least a year together for at least a year before you move to the nursing home, then you can transfer the house to your sibling without a penalty. So this doesn't happen too often, but it happens. But what happens more often is the caretaker child exception. So if your child has been living with you for at least 2 years before you move to a nursing home, and during those 2 years you can establish that they've provided enough care to keep you out of the nursing home, then there's no penalty for a transfer to the child. Now in terms of how you establish the 2 years of care, they generally accept a letter from a doctor. So if a doctor says without his son's care during the last 2 years, he would have moved to a nursing home 2 years earlier, then that does the trick. Now, one trap that some people fall into is these are also exceptions for having, at least the caretaker child and the disabled child from the prior slide, are also exceptions for the house being countable when the person in the nursing home applies for benefits. But they are not exceptions for the MassHealth lien and estate recovery, which we're going to get into in a minute. Here we are. Here's the slide. So, as I often say to my clients, with the house and MassHealth, they don't get you coming. It's not a problem for becoming eligible for MassHealth, but they get you going. So they seek to recover whatever they spent for your care, either from the sale proceeds if you were to sell the house while you're alive, or from your probate estate if the house is in your probate estate when you die. And they can recover whatever they paid for your care in the nursing home, or in addition, any MassHealth they paid for your benefit after the age of 55, whether it's nursing home MassHealth or not. So if you or someone you know is receiving MassHealth and they're under age 55, there's no claim against that person's estate. So ways to avoid the estate recovery claim. One is basically to avoid probate. So to put the house in a form that so it doesn't go through probate. And so probate is anything you own in your own name alone goes through probate. But anything you own as jointly with somebody else, jointly with rights of survivorship, will pass without going through probate. And then there's no estate recovery. A life estate. So in a life estate, which is a form of property ownership where the person called the life tenant co-owns the property with the people called the remaindermen. So typically a parent will create a deed creating a life estate saying, I give my home to my children, retaining, however, the right to live there as a life tenant for the rest of my life. In that case, it's a life estate. All the parent, and let's say they have 2 children, all 3 of them are actually owners of the house, but they have different rights of possession. So the life tenant has the total right of possession during her life. So she can live in it, she can rent it out, she's responsible for maintaining it. It's her right of possession during her life. The remaindermen have an ownership interest, but they can't take possession until the life tenant dies. So the property cannot be sold without everybody signing the deed, because they're all owners. But the remaindermen have no rights to enter the property. They have no right to rent it out. they don't have the obligation to maintain it. Of course, they may, if the life tenant isn't maintaining it, they may want to step up and do it just to preserve their own rights. So that's a life estate, and one beauty of a life estate, it's really easy to create. You just do a deed. And we're going to get into the pros and cons of life estates and trusts in a minute. So the other method of avoiding probate is to put the house in trust, and for mass health planning purposes, it has to be an irrevocable trust. And as some of you may know, MassHealth has been attacking irrevocable trusts in recent years. So a lot of trusts that we and other attorneys prepared 10 to 20 years ago have provisions in them that MassHealth has attacked. Now the reality is, in most cases, those trusts have survived the attack, but they have had to go through a lot of strom and germ to do that. So MassHealth has denied the cases. They've had to go to appeal, an administrative appeal at a fair hearing, and then if they lose that, then they actually have to go to Superior Court in what's called a 30A appeal to appeal that. So that's and then we're going to get a little more of that into the trust, but I guess I have a slide that says this a little later, but if you have a house in an irrevocable trust and it's more than a few years old, you should have it reviewed by an elder law attorney. The newer ones are okay because now we've seen everything that MassHealth has come up with so far, at least, and we've been able to draft around those, so the newer trusts are more likely not only to survive challenge, but not to be challenged in the first place. So getting back to the waiver or postponement of MassHealth's estate recovery. So I said that if you die and you own a house and you receive MassHealth, and it's in your probate estate, MassHealth has a claim against it. However, they will not seek recovery. So there's two circles here, and the blue is a postponement of recovery, and the green is you escape estate recovery entirely. So if a surviving spouse is living in the house, or actually in that case they don't have to be living in the house. So if you have a surviving spouse, or if you have a child under age 21, or a blind or disabled child, then they will not demand payment until those people, either a child under age 21 gets to be over age 21, or you no longer have a surviving spouse. I want to check that law. I might want to get back to people. I'm not sure if it's true on the blind or disabled child that they don't need to be living in the house. So we'll confirm that in the legal guide. But in any case, this has always confused me because, say, husband owns a house, he goes in a nursing home, he goes on MassHealth, and 3 years later he dies, and his much younger wife inherits the house, and MassHealth has this postponed claim on that house, and I haven't had the experience in all these years to understand how that works, because they have a right to recover from her estate, but I have no idea how they track that. It's pretty confusing. But anyways, that's what the law says. But there's also a hardship waiver, which is not a postponement. It's totally getting out from under, but it's very hard to get. So if a beneficiary of the nursing home resident's estate, a MassHealth recipient's estate, is living in the house and their income is under 133% of the federal poverty level, and if it's a family, they have different numbers if you're single, married, family, depending on how big it is, then they will waive the hardship waiver, but it's conditional for the first 2 years, and then after 2 years, it can become permanent. Now, one thing to be very careful of, if you're depending on the hardship waiver, is there are a lot of deadlines in the law. and very strict time limits. So if you qualify for the hardship waiver, you have to apply within a certain number of days of the death of the MassHealth beneficiary or when the probate is filed, in order to even seek the hardship waiver. And they're very rigid about that, unfortunately, which I don't think makes sense. So that's the picture. So you can keep your house if you're, in most cases, if you're getting MassHealth, but also in most cases, unless it passes outside of probate, you will it'll be subject to claim when you die for whatever they paid for your care. And that may be more, I mean, one issue, I can talk about issues to consider and then talk about life estates and irrevocable trust. One issue to consider is how big is that claim likely to be, in fact, because one benefit of getting MassHealth rather than paying privately is that MassHealth pays lower than the private pay rates in nursing homes. Nursing homes can charge up to $15,000 a month these days for on the private market, but MassHealth may be paying less than $10,000 a month. In addition, even when you're on MassHealth, in most cases, you're paying your income towards your care. So if you're relatively high income, that further reduces MassHealth's claim because it reduces their cost every month. So that's one thing to consider. Other things to consider is in terms of choosing between a life estate and irrevocable trust is what's the likelihood that you're going to sell your house? Because with a life estate, if you sell the house, part of the proceeds go to the parent as the life tenant, and part go to the remainderman. But if it's in a trust, it's all held in the trust, so it's not subject to either to having to be spent down for care or for having to reimburse MassHealth at that point. So the simplest approach to protect the house from any claim is to give it away and wait 5 years. So if you transfer your house to your children and you're fine for the next 5 years, then it's out of the picture, basically. So there's no claim against it, no spend down. It could be sold, and the proceeds don't have to be spent down. But there are potential problems with this. So you can transfer a house to a child who's disabled, and there's no penalty period. But if you transfer it to a child who's able, or children who are able, you cause the 5 years of ineligibility. Now that's probably true with that's going to be true with the life estate or the trust as well. But a bigger issue has to do with capital gains. So just as an example, let's say you paid $100,000 for your house a long time ago, and it now has a fair market value of $500,000. If you sell it, you have a capital gain of $400,000. I'm simplifying this a bit, so we're not talking about any improvements there may be to the house. So if your children, and if you give the house to your children, they inherit it with your basis. The basis is the $100,000 you paid for it. And when they sell it, unless they move in, they're going to have to pay tax on that $400,000 of gain. Now, I say unless they move in, because if it's your own home, you can exclude $250,000 of gain, and pay tax on it when you sell it. And of course, if you're married, you can together exclude $500,000 worth of gain. But that's a potentially high tax cost to transferring the house directly to the kids. In addition, it's at risk. So it's at risk if you have more than one child, they disagree on what to do with the house. If they have marital disputes or get divorced, it's an asset of theirs which could come into play in division of assets, or if they run into financial trouble. So if they go bankrupt or they get sued, it's their house, and it's their property, and it's likely to be subject to claim. In addition, if you give it away, even though we're talking about protecting houses because we don't want to dip into the equity in the house, in some instances you may want to dip into the equity in the house. You may want to have a home equity loan or reverse mortgage to pay for the care so you can live in the house, and that would be up to your kids at that point. And other things that are up to your kids are whether to keep the house and whether to let you stay living there. So you're really putting yourself at some risk, and for some people that's a risk. They don't feel as much of a risk, and they're willing to take that risk, and this is the simplest approach. But for others, they'd be wiser not to take that risk. So life estate is a good kind of intermediate solution. It's a simple to do. It's a transfer to the children, and it protects most of the house, and it gives the kids what's called, this is step up in basis. So when you create a life estate, when you die and the property passes, the ownership passes to the children, at that point the basis becomes the value on the date of death. And when they sell it, in our example of the $500,000 house, the basis is now $500,000. They sell it for $500,000, and they pay no tax. Do you have any cough drops or anything, or hot water? Just in case I'm going to get a little catch in my throat. So, and there are other benefits to a life estate. You have the right to live there for the rest of your life. You can rent it out and get the proceeds. No one can kick you out of it. On the other hand, you still need your kids' cooperation to sell it or to mortgage it. So you still want cooperative kids. So there are pros and cons, but it's a much safer approach than an outright deed. And even though it's the property of the kids, and it's still subject to claim upon their divorce or having financial troubles, they have a property interest, but no one can collect on it while you're alive. So you can still live there without any problem. So as we mentioned before, other issues with life estate are if it's sold, the proceeds are divided between the life tenant and the remainderment based on the life expectancy of the life tenant. And so that can cut either way. They might want to have some cash, they may need it, so that might be a good thing, or it may leave some funds that are unprotected, especially if they're in a nursing home at that time. They are, so that may be good or bad. If it's not going to be sold because you want to protect the proceeds, then the family members have to come up with the money to maintain it during that time. Because if they rent it out, you can the net rental income still goes to the owner, the life tenant owner, and would go to the nursing home. Of course, that's the net rental income, so the costs can be deducted from that. So that there are pros and cons. I think one problem with a life estate has to do with capital gains, because in most cases, and I'm going to go to a possible exception in a second, say I create a life estate and when my kids have their remainder interest and we sell the house, the proceeds are going to be distributed in part to me and part to my kids, and the part that goes to the kids, they won't have a step up in basis yet because I'm still alive. So they're still going to have to pay capital gains tax on their share, even though in all likelihood my share is going to be under $250,000 and I won't have to pay any capital gains tax. That's what this slide's about. One way to protect against some of these things is to put a limited testamentary power of appointment into the life estate. So this is how we do in our office. So our life estate deeds say, I give my kids my house, I retain the right to live there the rest of my life, and I retain the right in my will to basically disinherit my kids. So a few benefits. First of all, my kids better still be nice to me, because I might disinherit them. Two, it's for tax purposes, so this is more academic than anything else, it's not a completed gift, so I don't have to file a gift tax return. No one does anyway, but technically if you don't have that, you're supposed to when you create a life estate. They get a step in basis either way. And there's at least an argument, if I do this, that we sell the house, that we can exclude all the capital gains or apply the $250,000 exclusion on the sale of my house to the entire proceeds. It's a little bit of a gray area. So before we get into the irrevocable trust, and I see I'm going over time here a little bit.
Okay.
The main advantage, besides being simple, of a life estate over an irrevocable trust is it's reversible. So in our office, we basically prefer irrevocable trust, but if someone comes into me to see me or see one of us and they don't think they're going to make necessarily the 5 years to get into the nursing home, and they don't have enough cash to pay for their care during the full 5 years, then we might do a life estate. And the advantage of the life estate is, let's say I create the life estate, 2 years later I have a stroke, I go to a nursing home, and I still have this 3-year penalty period remaining, and I don't have enough money to pay for my care during those 3 years. My kids could reverse the life estate by conveying back their remainder interest to me, and then the 5-year penalty period disappears. The house is no longer protected, but at least there's a way to pay for my care. So it allows for some more flexibility in those situations. So, an irrevocable trust. So advantages of an irrevocable trust. First, it permits the sale of the house, and all of the proceeds are protected because they stay within the 4 walls of the irrevocable trust. It allows some finer tuning of the planning. So what happens to the house proceeds after you die, rather than just belonging to the kids? It can stay in trust for their benefit. Can provide some creditor and divorce protection. It can say that if, say, my son dies, the money doesn't go to his wife, but it goes to my grandchildren, things like that. You can put other assets into it to shelter them. You can still continue to get the income. You can say that the income comes to you, but the principal can go to the other beneficiaries. You receive the step up as you do with the life estate. But it's clear here, than even with the testamentary power of appointment, that the trust can be drafted so that it's not a gray area whether you can take the whole $250,000 capital gains exclusion if it's sold during your life, or $500,000 if you're husband and wife. As I said, the kids still get a step up in basis. So we feel that there are a lot of advantages to the irrevocable trust, but we charge more to set it up because it's more complicated, and it can't be reversed. It's irrevocable. So you got to be sure that you can figure out a way to pay for your care during the subsequent 5 years if you are to need it. One issue is don't be the trustee of your own irrevocable trust. That's something MassHealth doesn't like. Technically, it shouldn't matter. Whoever the trustee is, they got to follow the trust rules, but that's the kind of thing that's going to get you a fair hearing and perhaps a superior court case. So name the children or somebody independent to be trustee. That's important. As I said before, MassHealth has been finding little things in trusts that it can nitpick at to argue that they're not that the assets, the house or other assets, are still available to you. So if you have an old trust, make sure you get it reviewed. If you have a new trust, it should be fine because we think we've seen all the arrows in their quiver, and because we haven't seen any new arguments on their part in recent years. And that's the story.
All right. Thank you, Harry. So obviously we see MassHealth is complicated, needless to say, so definitely if you can talk to someone and make the right choices. With that, we will have our legal guide that supports what the presentation you saw today, so check back on our website in the next few days and that will be up. It will be called MassHealth Planning and Real Estate in our legal guide section. So we do have time for some questions, so let me see what's there.
Here you go. I'll let you control that.
Okay.
It's always hard to read.
I know, it is hard to read. Okay, so let's start. Oh, just as far as the slides, we will have the recording of the presentation on YouTube. If you're interested in seeing the slides, just email me, bck@margolis.com, and I can get those to you as well. Okay, so that was question one. I was able to answer that one. Okay, let's see here. What about an elder's joint saving or checking account with a non-spouse? Are those considered transferred assets if the non-elder withdraws funds from the accounts?
Yes. So this gets a little bit away from houses, but in real estate. But I'm happy to answer the question. So if the non-elder withdraws the funds, it will be presumed to be a transfer. Now you may be able to rebut that presumption by showing if it actually wasn't the elder's money to begin with. So if the child put the money in to begin with and added, say it's a single child with unmarried and no children, they put the parent's name on it just in case something happens to the child, then and you can prove that, then it's not going to be counted as the parent's money, and if it's not counted as the parent's money, then it's not going to be any withdrawal is not going to be a transfer. An interesting distinction, however, is MassHealth treats bank accounts, jointly owned bank accounts, differently from jointly owned investment accounts, say at Fidelity or someplace like that. So the presumption is if I own a bank account with my daughter, then the presumption is it's mine, and we'd have to rebut that presumption to show it's my daughter's money. On the other hand, if I have an account at Fidelity with her, the presumption is going to be that it's 50-50. So it would be possible to withdraw half of that without that being penalized. However, beware that the act of putting my daughter's name on the investment account, since it's considered that would make it half hers, is a transfer of assets. So you can't kind of trick the system by putting somebody else's name on the account this year and having her withdraw the money next year and say, well, now that half was her money. You can do that after 5 years, but not before 5 years.
Okay. If an out-of-state house that is currently in a state is put into your name, legally will you be able to requalify for MassHealth healthcare benefits, or does having a house in your name count as an asset disqualifying you and in the income section even if you don't get income from it?
So everything I've been saying about the house is your house. So it has to be have been your principal place of residence, currently be or have been in the past. So and basically MassHealth doesn't want to be paying for out-of-state residents. So if say you lived in New York and you moved to Massachusetts for care because your kids are here, you are not going to be able to exclude that house, your house in New York, as a non-countable asset. So it's a countable asset. Now they'll give you time to sell it. So if you have it on the market, they'll deem it as inaccessible, which is different from non-countable, for a period of time while you're trying to sell it. But it's going to be a countable asset.
Okay. I think we have time for two more.
Okay.
2 or 3 more. Okay, so let me see here. Some attorneys include an occupancy right in the irrevocable trust or enter into a lease agreement with the grantor rather than using a life estate. Can you please opine on this?
So we've gone back and forth a bit on that. So it's certainly a lot cleaner to have a right of use and occupancy in the trust, but that was one of the things that MassHealth keyed in on for a while, saying that makes it a countable asset. I believe there's been some good cases recently that said they're wrong. So I think now if you have a new trust or even an old trust with using an occupancy right in it, you're okay. But for a long period of time, we took that out of our trust, and we had a side use and occupancy agreement that was not part of the trust. We didn't do leases, but you could also do a lease. One advantage of having either one or the other of a lease or a use and occupancy agreement is the potential problem, if you don't have one or the other, is that if you pay for maintenance of the house that's in this trust, there could be an argument that you're making a contribution to the trust each time you pay the you pay the real estate taxes or anything like that, because that's really a benefit to the trust that you're paying an expense of a trust asset, which is the house. But if you're obligated to do that under a use and occupancy agreement, whether in or out of the trust or the lease, then MassHealth can't make that argument.
Okay, so we've touched on this one before, but I'll let you answer it. How are IRAs and 401k plans treated?
So for, in almost all cases, those are countable assets and would have to be spent down. And again, this is Massachusetts rules. The rules on this differ from state to state. In Massachusetts, there's one exception. So if you're still employed, your employment-related plan, so a 401k or 403b plan, or if you're a state employee, a state-related plan, is a non-countable asset. Now you might say, how can you be how can you be in a nursing home and still be employed, quote unquote? I think I've only seen it happen in one case in my practice where a person was on disability, permanent disability, but for some reason were still treated as employed. But a few more times we've seen in our practice situations where the spouse is still employed and still has a 401k plan, and that can be sheltered from having to be spent down to the $123,000 in that case. In one case, we were able to consolidate a wife's retirement plans with former employers with her current employer, and that worked. That was a non-countable asset.
Okay. What about a deed with a life estate with the remainder into an irrevocable trust?
Okay, so we've seen this a lot of times. So you have a remainder interest held by an irrevocable trust. So it's a kind of combo of the two things. There are pros and cons. I don't know that we've ever done it in our office. The nice thing is that MassHealth seems more comfortable in most cases with life estates than with trusts. So that's a benefit. And the other of having a life estate as part of it, kind of the rights of the life tenant are really clear. And so that's good. Sorry, I was distracted by someone coming to the door. And then if you sold it, then some of the proceeds would go to the life tenant, and the trust could be written so that you still get the Section 121 exclusion on capital gains completely. So there's some benefits, but I don't know, it's kind of simpler either to have a life estate or an irrevocable trust. There are a few cases where we've had the remainder held by a nominee trust, especially when there are a lot of kids. So you don't want to necessarily want to have a house owned by the parent and 6 kids and have 7 owners having to deal with it. So you may have a nominee trust holding the remainder interest with 1 or 2 trustees for the benefit of all the other beneficiaries. So that we've done that more often than a life estate and an irrevocable trust.
Okay, so there are more, but we don't have any more time today, but we will get back to you on questions we didn't answer. We do encourage you to continue the conversation. I don't know if everyone knows about this, but Harry has another site called askharry.info, and it's really a great site for any questions you have. He'll respond. Great legal resource, so please don't hesitate to reach out. So thank you to everyone for attending. We hope it was valuable and useful for you. If you have any topics that you're particularly interested in, you can get in touch with us via askharry.info or send me an email, because we want to make sure we're providing things that are relevant to your needs. And thanks again, Harry. We will have a recording of the presentation if anyone wasn't available to attend, and if you want to pass it along to colleagues or family members within the next week. With that, please see all our contact information if you need additional follow-up, and hope you enjoy the rest of your day, and happy Thanksgiving.
Yeah, have a great Thanksgiving, everybody.
Thanks so much.